Hello, everybody, and welcome to week 2 of Torts 1, Law 5110A, here at California Southern University School of Law. This week, we are going to start our discussion of intentional torts, which we will continue into next week. Intentional torts are the group of torts that include battery, assault, false imprisonment, intentional infliction of emotional distress, trespass to land, trespass to chattels, and conversion. As the name implies, intent is key in the intentional torts. That means that the tortfeasor, the person committing the tort, must have the requisite intent to commit the tort. So, what is intent? There's several different definitions that you'll see from the cases, but essentially they all center around this theme. Intent is when an act is done for the purpose of causing contact with the other person or causing an apprehension that such contact is going to occur, or the act is done with knowledge that such contact or apprehension is substantially certain to be produced. And keep in mind that substantially certain language is going to factor key into several of our cases we're going to look at. So to start off with, we will look at the case of Garrett versus Daly. Essentially the question in this case is whether a 5-year-old little boy has the requisite intent to commit battery. The facts here are that 5-year-old Brian Garrett was in his neighbor's backyard. Mrs. Garrett, one of his neighbors, attempted to sit down in a lawn chair, and she alleges that Brian pulled it out from under her at the last minute, causing her to fall. The facts, as relayed by little Brian Garrett, are that he moved the chair for himself to sit in, and then he saw her trying to sit down, and he attempted to put the chair back. He was 5 and not strong enough to put the chair back in time, and she fell and broke her hip. So she sues little Brian Garrett for battery. So the issue becomes, did Brian have the requisite intent to commit the harm caused to Ms. Garrett? So we look at, what does intent require? So intent is the act was done for the purpose of causing the contact or apprehension, or the act was done with the knowledge that such contact or apprehension is substantially certain to be produced. Furthermore, from this case, the court says it's not enough that the act was intentionally done. Even if the actor realizes or should realize there's a grave risk of bringing about the contact or apprehension, this may make the act reckless or negligent. The actor must realize to a substantial certainty that the contact or apprehension will result, and without this, there is no intent. So even if the actor has an idea that the harm is going to result, and intentionally does the act knowing that the harm could result, it's not enough for intent. The intent has to be that there's a substantial certainty that the harm will result. So what does that mean for the Garrett versus Daly case? There was a dispute of facts in the case, her version versus his version. The trial court accepted his version and held that there was no intent. The Supreme Court in the state of Washington held that Brian could theoretically have had the intent to cause harm, even though he's only 5. So the court held that if Mrs. Garrett's version of the facts were true, if Brian had intentionally pulled the chair out from under her as a joke or whatever, then he would have had the intent to cause her harm, because he would have been doing it with the knowledge and with the intent that she would fall to the ground. So if the court finds that he does have the intent, then several other factors would be irrelevant that you may think could mitigate the risk or reduce his liability. It would be irrelevant that he did not intend to injure. Say he pulled the chair out hoping that she would fall down, and then it would be funny, but he didn't really intend for her to get hurt. It doesn't matter. That he was only playing a prank or he only wanted to embarrass her doesn't matter. That he didn't intend to commit an assault and battery doesn't matter. If he has the intent and does the action, then he could be liable for battery. So in this case, ultimately, the court remanded the case back to the trial court to conduct a hearing to determine whether Brian knew with substantial certainty that Garrett would fall when he moved the chair. Before we move on, there are a couple other issues here, and we'll talk about these more generally later. The first issue is this is more of a practical issue than it is a theoretical issue. I know in law school classes, especially at this level, we talk a lot about the rules of law and the theories behind intent and battery and assault, and that's what we're going to be talking about here. But I wanted you to think about, why would she sue a 5-year-old for battery? Assuming his parents are not liable for his actions, would she expect to collect money from a 5-year-old child? So this is one of those instances that maybe legally, theoretically, she could have a case against Brian. She could get a judgment against Brian, and that would be fine. But practically speaking, how would she collect this? Would this be a viable case that she would want to bring against him? And secondly, this case sort of assumes, because it's in the intentional tort part of the book, that she sued him for battery, and that was it. What you would likely see in these kind of cases is an alternate pleading of, probably count 1, battery, and count 2, negligence. If the court could find that he didn't intend to cause the harm, but could find that he was negligent in moving the chair. So that's just a couple of asides that you should keep in mind when you read these cases. Not all the time is it just an issue of, is this a battery or not a battery? A lot of times these cases are pled in the alternative with a number of different theories. So moving on, there are a few other cases centering on intent in this week's reading. The Spivey case, a defendant gives plaintiff a hug. It was a friendly, unsolicited hug. As the book says, she was shy, and he attempted to give her a hug. But somehow he ended up causing injury to her head and neck. Must have been one hell of a hug. Plaintiff sues for negligence and battery. Defendant argues that it was a battery and not negligence because he intended to commit the act, and that the battery action is barred by the statute of limitations. And you should all know what that is from civil procedure. If you don't quickly, it's statute of limitations, puts a time limit on when you can bring an action in court. If you wait too long, then the action is going to be barred. So the court looked at this case and looked at the intent of the defendant and said that it cannot be said that a reasonable man in this defendant's position would believe that the bizarre results herein were substantially certain to follow. In other words, this is such a weird and bizarre injury from someone trying to hug someone else that the court thinks that there's no way he could have known that the harm was substantially certain to follow. In the lower court, they did not submit to the jury the elements of negligence because they bought the fact that this was supposed to be a battery action. So the appellate court here held that he didn't have the intent, but that the court should have submitted on the elements of negligence. The Ranson case from Illinois, defendants killed plaintiff's dog believing in good faith that it was a wolf. The court upholds the judgment, saying defendants are liable for their mistake. The intent issue is there intent if you commit a battery against someone or something other than, if you're mistaken? Say, in this case, it's a dog, but let's say you are intending to shoot person A with a gun, and the person A is pretty far away from you. You're pretty sure that the person you see is person A. You shoot them, and you go up and find out later that, no, they were not person A, you were wrong, it's person B. Can you make the argument that, well, you didn't intend to commit the battery against person B because you thought it was person A, you intended to shoot person A, so you never intended to shoot person B, it can't be a battery. Well, that argument doesn't fly. It's for the same rationale as you see in the Ranson case. If you committed the act itself intentionally to cause harmful contact, or knew that the harm was substantially certain to result, there's a battery. If you shoot the wrong person, the intent was you intended to shoot somebody, or you intended to fire the gun, and were substantially certain that the person would be shot thereby. So the fact that you're mistaken as to who you're shooting, or they're mistaken as to what animal they're killing, is not a defense. In the McGuire case, This involves a nurse taking care of a woman who was mentally ill and confined to her home. At one point, the woman started having a violent episode, and the nurse went to confront her. The woman held up some sort of held up some blunt object and threatened her nurse. The nurse proceeded to try to get it from her, and the woman struck her in the head. So the issue here is as the court would say, is an insane person liable for battery? The court looks at the intent of the insane person, sort of similar to that of an infant. See the Garrett case above. In other words, did the defendant intend to act in a manner to cause harmful contact, and then did so act? In this case, the court looks at it and says yes, even though she has a lot of mental illness and she was having a violent episode, she held up the blunt object with the intention of hitting the nurse. She did then hit the nurse, and the harm resulted. Her intent was to cause the harm by hitting her, and that's what she did. Therefore, she has the requisite intent. The court's not going to delve into her mental illness with a view towards excusing the behavior. And the last case is the Talmadge case. It's in your assignments for this week to brief that case. If you have any questions on that case, feel free to shoot me an email or a phone call. So let's move on to the first of the intentional torts we're going to talk about. Those first couple of cases are all about intent, and we talked about battery in some of those cases, but those are all talking about what intent you have to commit the intentional torts. So in the battery context, battery is the intent to cause harmful or offensive contact with the person of the other or a third person, or an imminent apprehension of such contact, and the harmful contact directly or indirectly results. So battery has a number of key factors here. You have to have intent, there has to be harmful or offensive contact, it has to be with a person, and there has to be an imminent apprehension of such a contact, and harmful contact directly or indirectly results. As the book points out, every battery includes an assault, because when you're going to batter somebody, you also commit an assault by giving them a reasonable apprehension that you're going to commit a battery. But assaults alone do not include a battery. We'll see in a little bit that assaults are essentially an attempted battery, or when you're giving someone the impression that you're going to commit a battery, but you don't actually make contact. So in the Cole versus Turner case from 1704, a very short case in the book, they define battery as the least touching of another in anger is a battery. Let's look at the Wallace versus Rosen case. So in this case, there was a fire drill at a school. Wallace was a teacher at the school. She was attempting to move her students down the stairs and out of the school. If you've ever been inside of a school building during a fire drill, you know how crowded it can be. All the students are trying to file out and go down the stairs and get out of the building. Rosen was the mother of one of the students at the school. She was there to bring her daughter some homework assignments. They were standing on the stairs with a couple of her daughter's friends talking when the fire alarm went off. They were still there as the students were trying to exit the building. The teacher, Wallace, came up behind her and tapped her on the back to get her attention, and that's where the facts sort of diverge. Wallace says she touched her on the back to get her attention and tell her to move. Rosen says she pushed her down the stairs. So the court looks at this sort of with the eye of, well, she admitted she touched her at all. She admitted she put her hand on her back. Was that contact with Rosen sufficient to meet the standard for battery? The rule is battery is the knowing or intentional touching of a person by another in a rude, insolent, or angry manner. That's what the law of battery is in the state of Indiana. So the court looks at this and says, yes, there's a substantial certainty standard for intent. Was Wallace substantially certain that this harm would result if she committed the harmful or offensive contact? The court then delved into what several people have analyzed in the context of battery, that we live in a crowded society. There's a certain amount of touching that's inevitable in everyday life, such as the tap on the shoulder to attract attention. You're walking in a crowded hallway, you may bump into somebody, but absent expression to the contrary, Consent is assumed to all those ordinary contacts. So if you're living your life, you bump into someone on the subway, you tap someone on the shoulder to get their attention or touch their arm. Those you're assumed to consent to all those unless you expressly don't consent to them. In the context of a fire drill, as in this case, Rosen should expect a certain amount of ordinary touching. There's no evidence that the touching was done in a rude, insolent, or angry manner. Wallace wasn't hitting her to get her to move out of the way or shoving her out of the way. She touched her to get her attention. The court held that this is not a battery. Wallace touched Rosen, but not in a manner sufficient to constitute battery. Let's look at the Fisher versus Carousel Motor Hotel case. This is a case involving segregation in Texas. Plaintiff was a mathematician and an African American. He was at a scientific conference at this hotel. The conference included a lunch buffet. He was in line at the lunch buffet with his plate getting food, and someone from the hotel came up to him, grabbed the plate from his hand, and said that a Negro could not be served in the club. He didn't actually commit touching on Fisher's body, but he just grabbed the plate away. So the issue is the intentional touching of an object that another person is holding, such as grabbing a plate away, sufficient to constitute battery? The court held that yes, this is an offensive contact. Unpermitted and intentional contacts with anything so connected with the body as to be customarily regarded as part of the other's person and therefore as partaking of its inviolability is actionable as an offensive contact with his person. The court looked at another Texas case where a book was forcibly pulled out of someone's hands and held that that was a battery. It's analogous to this case. The court says that the grabbing of Fisher's plate in a forceful manner, combined with the offensive comment, are sufficient for this to be an intentional offensive contact with Fisher. Because he was holding the plate, they look at it the same way as if you touch someone's clothes or grab someone's clothes, something that's that intimately connected with their body. If you commit a harmful contact on that, it's the same as having a harmful contact with the body. The damages here are mental suffering, and they're recoverable on a battery without having to show an actual physical harm. So the conclusion was a battery was committed when the plate was intentionally grabbed from Fisher's hand in a rude, insolent, and offensive manner. So let's look at assault now. An assault is, in contrast to a battery, an assault is defined as the intentionally putting another person in a reasonable apprehension of an imminent, harmful, or offensive contact. There's no intent to cause physical injury that needs to exist, and no physical injury needs to result. So you can commit an assault on someone without actually intending to hit them or make a contact with them, or without intending to physically injure them. All you need is the intent to put them in a reasonable apprehension of an imminent, harmful, or offensive contact. In other words, you intentionally make them think that you're going to hit them or commit a battery against them. Essentially, this assault in tort law can be viewed as an attempted battery. No actual touching or attempt to touch need be present, just the reasonable apprehension of a contact. So let's look at some cases. Western Union Telegraph. This case involved the plaintiff and defendant. Here, the defendant was under a contract with plaintiff to fix a clock. The plaintiff's wife had called the defendant and said that their clock was out of order and needed to be fixed. Nobody showed up, so she went down to the desk and saw the representative of the defendant sitting there. The facts say that he had a few drinks in him already, and she said that somebody needed to come fix the clock. He made a sexual advance at her and tried to reach over the counter and grab her and say that if she came into the back with him, then he would fix her clock. He never actually made contact. So the issue is, were defendant's actions sufficient to constitute an assault? He reached for her. He did not touch her. He did not grab her. The court said every battery includes an assault, but not vice versa. Assault is an unlawful attempt to commit a battery, incomplete by reason of some intervening cause. There must be an intentional, unlawful offer to touch the person of another in a rude or angry manner under such circumstances as to create in the mind of the other person a well-founded fear of an imminent battery. with the apparent present ability to effectuate the attempt. So it's a lot of rule there, a lot of highlighted words, but essentially in this case, defendant reached out to the woman, tried to grab her. There's a testimony that the counter between the two of them was very wide and very high, so he couldn't actually reach over the counter. He could reach just to the other side of the counter. So that prevented him from touching her, and she also jumped out of the way when he attempted to touch her. So the court held that this case should go back to the jury, back to the trial court for determination of the facts. Under the circumstances of this case, could he have possibly touched her, and was he trying to give her the apprehension that he was going to grab her, or was it so impossible for him to get a hold of her because of the way the counter was set up that he could not have committed an assault because there's no way he could have grabbed her? So false imprisonment is the last intentional tort we're going to talk about today. And false imprisonment essentially is when you put an act of restraint on another person which confines them to a bounded area. One other key factor of this is that it has to be unlawful. Obviously, the police will put an act of restraint on a criminal suspect and confine that person to a bounded area. So false imprisonment is essentially confining a person, putting an act of restraint on that person in a bounded area with an unlawful reason. So bounded area is important. Area is only bounded if the freedom of movement is limited in all directions. If there's a reasonable means of escape from the area is not bounded. If you tell someone, sit on the curb here at the street and don't move, is that person physically restrained in a bounded area? No. If you have a gun on the person, maybe, because the act of restraint then in that context could keep them in that area that may be considered bounded. But essentially you have to have the person bounded in an area. Usually this is a room or unlawful arrest for a jail cell, something like that. So there are 4 cases we're going to talk about with regard to false imprisonment, and you'll get a little feel for the limits of what false imprisonment are. Big Town Nursing Home versus Newman. This is an older gentleman, was placed in a nursing home by his nephew. He had some problems with alcohol, but wasn't considered mentally ill, wasn't considered an alcoholic, and wasn't placed in a special ward where the nursing home took care of those kind of patients. The admission papers did not say he was being held against his will. He was never told he was being held against his will. There were several times he tried to leave the nursing home, and each time he would be caught and brought back. He was placed into a special ward where they treat mentally ill patients and senile patients and alcoholic patients. He was strapped to a chair at some point. So every time he escaped, they tried to bring him back. He eventually got out completely and filed this lawsuit. So the false imprisonment is the direct restraint of one person of the physical liberty of another without adequate legal justification. The court looked at the facts here and said this was a false imprisonment. There was no hearing or proceeding that allowed them to legally confine the plaintiff against his will. There was no evidence that he was senile or mentally ill or dangerous. So essentially they had no legal right to keep him there and bring him back and restrain him into the nursing home. In Parvey, the issue comes up, and this is somewhat of a philosophical issue. Must the plaintiff be aware that he is being falsely imprisoned for the action to be sustained? Can you have a false imprisonment if you're not aware that you're being falsely imprisoned? In this situation, a plaintiff was detained by the police because he was drunk and needed to sober up. Later, he admitted to having no recollection of the incident. So after the incident, he admitted in court, I don't remember it at all. So the court looked at it. The defense said, well, he doesn't remember it. You can't have a false imprisonment if he's not aware that he's being falsely imprisoned. And the court said, look, generally that's true. If you cannot confine someone to a bounded area for an unlawful reason if they're unaware of it. And we'll give you the example of if someone is passed out in a room and you lock the door to that room, which will prevent them from getting out, and they are unconscious the entire time, and then you unlock the door at some point so they can leave, and they remain unconscious the entire time. Have you committed a false imprisonment? Most courts would say, no, you haven't. They have to be aware that they're being confined, and in that situation, the person would not be aware. In the Parvey case, the court made the distinction between knowing at the time of the false imprisonment that you're being confined and not being able to remember it later on. In this case, they said there was sufficient evidence that he knew he was being confined at the time that the confinement was going on. He followed the directions of the officers. He got into their car with them. He knew what was going on later on, though. When he sobered up, he didn't remember anything. But that's different from not knowing what's going on at the time that it's happening. The Hardy case, this was a suspected shoplifting case. The plaintiff worked in a jewelry store. One of her co-workers thought she saw her steal a watch. So the manager, under false pretenses, told her that he was going to give her a tour of the store, took her eventually to the manager's office and shut the door behind her. In the room was the manager, a loss prevention employee, and a uniformed police officer. They met for around 20 to 45 minutes, and then they determined that she did not steal the watch. So she left, and they apologized to her for the accusation. They said she can keep her job. She then sued for false imprisonment, and the court held that false imprisonment requires restraint of an individual against her will and unlawfulness of the restraint. In this case, they couldn't meet either of those. They couldn't meet either of those requirements. They said the restraint was not unlawful. They also said that she did not ask to leave the room. She was not told she couldn't leave the room. She admitted that she wanted to stay in the room and clarify the situation. There was no show of force. She wasn't being held against her will. They were not blocking the door. And she stated even if they had told her the truth, that she was being taken to the manager's office because of suspected theft, she would have gone willingly. So she wasn't being restrained against her will in any situation here. So that was not a false imprisonment. And then we have the Enright versus Groves case. This is a case where there was a dog running free in this Colorado town. The officer saw the dog. There was a violation that you have to have your dog on a leash. He saw the dog running loose. He saw it run up to the house where it lived, and there was a little boy outside. He told the little boy to put the dog away and asked for his mom. The little boy pointed to a car at the curb where the mom was sitting. The police asked her for her driver's license. She gave her name and address. The police asked for her driver's license again. She refused, and he said, "Give me your driver's license or I'm going to arrest you." She again refused, and he arrested her. Later, she was convicted of the dog at large ordinance violation. So the court looked at it and said, when a police officer has probable cause for an arrest or has a valid warrant, and then the person is convicted of the crime for which they are arrested, that's a complete defense. This is not an unlawful restraint. Police who have probable cause or have a valid warrant have a lawful reason to restrain you. And, if you're subsequently convicted of that crime, then it's a complete defense. Obviously, if you're convicted of it, then they had probable cause. So the court said, however, that rule doesn't apply in this case because given the facts of the case, the plaintiff was not arrested for, she was clearly not arrested for the dog ordinance violation. She was arrested because, as the police officer himself said, she refused to give up her driver's license. There was no lawful reason why he demanded the license. She had already given him her name and address. There was no law on the books requiring her to produce her license on command. So the police did not have probable cause to arrest her for failure to produce a license. Therefore, the arrest was unlawful. So let's look at some conclusions for this week before we break. So all intentional torts require intent. We talked about 3 intentional torts today: battery, assault, and false imprisonment. We'll cover 4 more next week. Intent is when an act is done for the purpose of causing contact or apprehension, and the act is done with the knowledge that such contact or apprehension is substantially certain to be produced. So when if you're make a contact with somebody for the purpose of causing harmful or offensive contact, or the act is done with knowledge that the harmful or offensive contact is certain to be produced, that is an intent. That's the level of intent you need. Battery is the intent to cause the harmful or offensive contact with a person, and then the harmful or offensive the contact directly or indirectly results. The assault is essentially an attempted battery. You put the person in reasonable apprehension of the harmful or offensive contact. And remember, you don't actually have to have the intent to touch them. You don't have to have the intent to cause them harm. The only thing you have to intend is that they believe that you're going to commit a battery against them. And then false imprisonment is an unlawful act of restraint on another person, which confines that person to a bounded area. So you have to be able to confine the person. It has to be within a bounded area. They can't have a means of escape. And it has to be for an unlawful reason. And you can see in the last case we talked about, even when it involves the police still have to have a lawful reason. So that's it for this week. If you have any questions, please give me a call or shoot me an email. And we'll see you here back next week to finish up our discussion of intentional torts.